Alrighty, me again. So, again, not an attorney, nor care to be. Um, don't really want to dumb myself down. I want to get smarter. So everything's opinion based. It's a learning video, and I never look straight forward. I always look around to be able to protect myself by any means necessary. All right. So this is gonna be part two of the video I just previously did, and let's try to adjust this a little bit better here. There we go. I think I got a little bit better anyway. Alrighty. Apologize. I just limited on things and it is what it is. All right, let's proceed forward on this.
Well, I am constantly bamboozled by what is happening here because I really don't know. It's fascinating that when anybody comes from a place of integrity and submits documents to be heard by the agency that is vested with authority under the Constitution to do something, to hear the case and make a determination, and they refuse to do it. Well, that's interesting. What do you do? I haven't shared so far about my case, and I'll do it very quickly. Basically, I was fined about $850,000 for allegedly not having a construction license here in California. The statute is Business and Professions Code 7031B. Now, what I discovered about it is that this is a purely penal statute, and they're supposed to notify you that you have the right to counsel, and the prosecution is supposed to be done in the name of the people of the state of California and by the district attorney. But none of that happened. This was all done in the civil context. And the private parties that sued me had no authority to do so, and the court therefore had no personal or subject matter jurisdiction to make any judgment whatsoever, because there was no subject matter jurisdiction vested in the court. In other words, the court had no authority to do anything that it did. It had a ministerial duty to dismiss the case right then and there because there was no power vested in it to conduct a criminal proceeding in a civil trial, or more accurately, for private parties to criminally prosecute other private people. So that's what happened to me. And then I went to an appeal and made a lot of the arguments that you'll find in the petition that's on the website. And the court said, we find no merit to any of your contentions. So I went to the California Supreme Court. They refused to hear my case. I filed a petition for writ of certiorari with the U.S. Supreme Court. And I don't know how many thousands of other cases they threw out at the swipe of a pen, they didn't want to hear it. So then I filed a lawsuit in the United States District Court here in the Central District of California. That's a, quote, federal court. And that court said that the federal government, sitting as the district court, does not have authority to vacate a state court's. Well, they didn't say they didn't have authority to vacate the state void judgment. They basically said that the judgment that was against me in the state court was valid, and that because it was valid, they didn't have any power to overturn it. Well, that's a lie, because the judgment's void because the court had no authority to do what it did. And so they had a duty under the Constitution to vacate the void judgment, and they refused to. So after that, I filed an appeal, and right when I did that, the district court told the Ninth Circuit Court of Appeals that my appeal was frivolous, and then the Ninth Circuit Court of Appeals said my appeal was frivolous, and it got thrown out. So there is essentially no court in the state of California or the United States that I have access to and am aware of, other than the U.S. Supreme Court, that has jurisdiction to hear this case and actually vacate the void judgment against me. So that's why, one of the reasons why I'm in the Supreme Court is there is no other court. And this judgment is now $800 and almost $50,000, where it will attach to any real property that I ever own. And it's also resulted in the permanent and indefinite suspension of my ability to ever act as a contractor in the state of California. And that was all done without any hearing whatsoever. So that's what the premise of the case is. Either of you want to share anything?
Oh my goodness! Number one, for openness here, $850,000, right? "Quote unquote," undefined dollars, paper money, which is beyond the subject matter jurisdiction of any state court. Article 1, Section 10: no state shall make anything but gold and silver coin a tender in payment of debt. We don't know what it is. And if defined at all, people, you're going to love this. And you get onto my website, uwinnincourt@gmail.com, and explain this. This beats them. Because the dollar, if defined at all, and this is the Supreme Court saying it, not me, is by the president, apparently acting as commander-in-chief of the armed forces. And what does that tell you? And why do you see the yellow fringe around the flag every time you walk in there? It's a martial law military court, which they can't do. And that goes back to a really big case called Ex parte Milligan, 4 Wall 2, 1866. That's when you run a lot about to get a hold of my materials. They simply can't do any of this. And yet, here they are, primarily for the reason that very few people, know enough like Adam and I do to even ask questions like this. The Supreme Court has to love this. And then you get into what they call their Ashwander rules for status and standing, which was on page 1 of the first law course I took in 1983. By the way, never been to a law school, and never been brainwashed by one either. But these rules, what do they say in there? The court will not rule upon the constitutionality of a law in the advance of the necessity of answering it. And they know damn well that no member of the Supreme Court bar in his right mind is going to bring an issue like that. They also know that 99.9% of us who don't know aren't going to have a clue either. And I think that's what lets the bastards go to sleep at night soundly, knowing that they've done their job, but it's not their problem that the American people don't know. It sure as hell is from where I sit. I mean, you just simply can't get around it like that. So we have that, and then, by the way, speaking of the California Supreme Court these days, and good old Tony Cantil Sequoia, I have from there and multiple times, but the one I sent in 2013, I believe, I did a non-statutory federal writ of habeas corpus that gets summarily denied. One paragraph that the questions you raise are beyond the jurisdiction of California courts as they appear to present federal issues. They don't have federal question jurisdiction? Whoa, I'm sitting there at that jail cell 5 years ago in South Carolina. The news came on and we had the situation that arose in North Carolina where an attorney was making a serious argument, albeit not in court at the time, that a transgender entity, your guess is as good as mine, had a right, to invoke federal jurisdiction because taking a crap in a government-funded bathroom affects interstate commerce. And the California Supreme Court is saying we don't have federal jurisdiction? If you know what you're reading, they're right. They don't have de jure federal jurisdiction. De facto under the non-existent 14th War Amendment is a matter of a whole different sort. They have that all over the place. They don't have this, and that's what they need. And what it means is that they're not a state admitted into this union, Article 4, Section 3. And not only that, Tony and the justices didn't have the courage to do this on the record, which if they had, they'd be out there in San Quentin, hopefully in close proximity to cell 2455 for treason. This was done by a deputy clerk of court. Have you ever heard of the doctrine of separation of powers here? And I've got no less than 12 different ones, not quite as dramatic as this, but the same thing. Summarily denied, just like what's happened to Adam. With no reason, no nothing, no opposition. And I'm going to ask all the official actors out there, if that's the case, and we're wrong, and we don't know why. How can we make a knowing, voluntary, and intelligent use of our right to vote on quote-unquote election day? It's not possible, but conveniently, as you'll learn from my website, there are no elections. And there can't be, because in federal insular territorial possessions, Congress is without power to provide for elections. I mean, for president, for voters. You ever heard of the Electoral College? Voting members of the House and U.S. senators, which is still an appointed position, notwithstanding the 17th Amendment, which was not ratified. They're not there. There's nobody in either House of Congress that has any standing to be there, let alone have a quorum to do business. These are the kind of issues we raise and start to get around these bastards, and it's going to work in Adams' case too, because the same thing is true in California. Oh, a quickie there, by the way. I know I'm running on a bit here, but think about this. Article 1, Section 2, U.S. Constitution, maximum relations between inhabitants and members of Congress, 30,000 to 1 in the House of Representatives. We have over 40-odd million people here in California, and we have 80 members in the California Assembly. Do the math. 500,000 to 1. Where is the Republican form of government guaranteed to the states by Article 4, Section 4? Another real beauty of the issue. And like many of the issues, Adam knows this too, the Supreme Court has rarely ruled on this. They hadn't ruled on it since 1842, Luther v. Borden, and they called it a political question at the time, and it might have been, but not the way we're going to be raising it. It's life or death here, literally, of the Constitution and of our lives and our posterity's lives. That's how serious this is getting. So, yeah, this is the kind of issues that we want to raise, get before the court, get before a common law jury, which has the power to rule on the facts and the law, as that pesky U.S. Supreme Court again, Brailsford v. Georgia, 2 Dallas 402. You had a right to that since the Magna Carta in 1215, Article 24, 34, and 42. And yet you don't see it anywhere. And oh, by the way, just a closing note here, we also have that right under the Article 2 of the Northwest Ordinance of 1787, which guarantees it to inhabitants of territories. And yet it's nowhere present in what purports to be the state of California. I'd love to get Tony to answer that question and see where the hell we're going to be going from there. But I went on a bit. Let me get back to it.
Georgette, you have some notes there?
Something you just said, Bill, about getting before a common law court. And the question just rose in me, is there a way you can get before a common law court, Adam, with some segment of what you're doing, or the whole thing, or, how does one get before a common law court?
Well, this is something that Bill brought up earlier, but in the way of the district courts of California. So every state in the Union, with the exception of Louisiana, was admitted under the common law. And so how it used to be that a constitution would vest the judicial power of a state or the United States in a judicial constitutional court would be, they would say in the Constitution, this court has jurisdiction in all cases at law, and oftentimes that was accompanied with at equity or inequity. And what you find now is that if you go to the California Constitution of 1879, there is no court that's vested with common law general jurisdiction. It just says the court has jurisdiction in all other causes. Well, what in the hell does that mean? There is nothing in the Constitution, history, and laws of California or the United States that talks anything about all other causes. What the whole point of having a court at law or a court of equity or admiralty is because there's very specific modes of proceeding and forms that these courts proceed under, and there's very specific types of relief that they can grant. So, like, to bring it back to my case, if you were to apply the common law to the Business and Professions Code that my case revolves around, first off, the Business and Professions Code wasn't even recognized at common law, so it's out already. Second, if they're going to say that the Business and Professions Code is the common law of California. Well, it's not, because the common law is the laws of England that came over here that were adopted in California. And the common law recognizes inalienable rights. That's what each of the constitutions was created under, was the common law. And the Business and Professions Code, obviously, if they're saying you have no right to your time and labor in construction whatsoever, obviously you don't have any right to anything. It's a privilege that they're granting you, commensurate with whether you pay a fee or not. So that's one aspect of it. Here's another one: is the fact that having a license creates a hypothetical injury, that you've injured somebody because you don't have their permission to have a license. Well, under the common law, you have to have an actual injury, and there has to be a nexus to that injury that they present evidence of. So you can't just make up something like, wearing pink on Fridays, it results in $1 million fine, because it's just purely hypothetical. It's not based upon anything, and there's nothing to tie it to the fact that an actual injury has occurred.
Yeah.
So,
So are you saying that there aren't any common law courts, and so therefore, it's not a possibility to actually?
Correct. And so that's why my case is in the Supreme Court, because if you read my petition, it also shows that there's not been any jurisdiction at law or equity vested in any lower federal court. So now, if there weren't any, wasn't a common law court in the state of California, you could go to a federal court, although they say there is no federal common law. The federal courts rely upon the common laws of each of the state. But when you start to look into the federal rules of civil procedure and the the statutory federal question jurisdiction that's been granted to federal district courts, you see that there's no actual law and equity jurisdiction that's been granted to them. So the only other court, and Bill, you can chime in on this, otherwise, that seems to be a judicial constitutional court that has jurisdiction at law or equity, is the United States Supreme Court. They are the only court created by the Constitution, and it says that the judicial powers shall extend to all cases at law and equity. Well, where is it? Because they just sent, the clerk just exercised it, if you will, and sent my case back. So we have someone who's a clerk of court who has no authority to exercise that power, sending the case back and denying every single right that's claimed therein under the Constitution. So now Bill will say, well, time out. There's two constitutions in California. One of them's the 1849 Constitution, one's the 1879 Constitution. And because the 1849 Constitution wasn't repealed when the 1879 Constitution was purportedly ratified, we still have those courts that exist under that Constitution. But he knows as well as I do that there is no such thing anywhere in sight, even if we go down there and demand that that's what we want, because, it goes back to something that, something you brought up or Bill brought up earlier that I was addressing, which is that it's very curious what's happening here, because either these people know what they're doing and they're deliberately doing it, or they have no clue what they're doing. And I mean, take it like this. In my case, they fined me $850,000. I have a Supreme Court case that came in 2020 that says what they did was a fine or a penalty, and they can't seem to figure out that that's what happened here. I mean, where do you even go with that? If the whole entire judiciary of California does not know what a fine is, where do you go with that?
Well, I guess, the thing that as I'm listening to both you and Bill speak, the thing that just keeps coming to me over and over again is stand in your power, stand in the standing. In other words, be common law, it's like if you keep putting out the vibe that what's the vibe? How do I want to describe the vibe? The vibe of being heard, being fairly treated, all those kinds of things. If that vibe keeps coming from me, then even the courts are going to somehow reflect that. That's, again, you all have all the knowledge about statutes and laws and stuff. I'm coming from a slightly different place in terms of energetically being what it is we want, for lack of a better way to say it.
I'm going to add on that real quick, Bill, and then you can talk. But Bill and I haven't talked in this regard, but Georgette and I have many times. And, a lot of what she's just talking about the energetics of all this, what's opening up is that the Constitution, the spirit of it, is actually written for all of us to stand in our power. And it embodies those principles of power, if you will. Georgette right now is going through a case involving foreclosure proceedings, and they basically, threw her out of court and didn't want to hear her. Well, guess what? Due process, or judicial process, as Bill calls it. Right there, you have the right to be heard. And if they don't want to hear you, it's the same thing in my case in the Supreme Court. There's all these principles that are embodied in the spirit of this law that, because all of this has been taken out of the curriculum and study of all of the public education institutions and probably even all the private institutions, no one seems to be getting this training on what it really means to stand in your power in this way, not just energetically, but even using the laws that have been created to reflect that embodiment of standing in your power. So I just felt that was really important to add, because it's like once you discover the power within yourself, you find that all these laws that not all of them, but a majority of them that are constitutionally based have, thousands of years of history behind them, and they're all about empowerment. So I'll leave it at that.
A couple of notes here about all that business, and what you say is right, by the way. Just recently, I think the term last year in UC Berkeley, courtesy of Ruben Chimere.
All right, so we're going to end it here. Stretch this one a little too long. It is mass, y'all. Till the next one. Peace of We the People News. Bye, y'all.